Welcome, and thank you for joining us today for part 8 of our Future of Work for New England Employers series. This installment of the series will focus on artificial intelligence and its impact on the future of work. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature on WebEx. However, if your question is not answered, our presenters will follow up with you directly in the coming days. For those of you interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Dan Klein.
Thank you, Andy. Good afternoon, everyone. Happy Halloween. We come to you with a really cutting-edge topic, and I'm sure a lot of you have been attending different programs on it. Today with me are Emily Miller, my colleague here in Boston, and Rachel C., one of our colleagues out of our DC office. In particular, I wanted to just tell you a little bit about Rachel's background because she truly is one of the subject matter experts in this area. Rachel returned to Cyfarth back in June. She had been over at the EEOC just before that for about 7 years. And while at the EEOC, Rachel led enforcement policy and digital transformation initiatives. She served as one of the commissioner's senior counsel for AI and algorithmic bias, leading initiatives emphasizing the applicability of employment discrimination laws to the use of artificial intelligence, and working to educate lawyers and HR professionals regarding the applicability of our civil rights laws to AI and other related technologies. She also served as the EEOC's acting executive officer, a special assistant to the EEOC chair, and as the EEOC's assistant general counsel for technology. So she really brings a wealth of knowledge and information in this space. And I should add that prior to her time at the EEOC, she served as the branch chief of e-litigation at the National Labor Relations Board. So with that, I'm going to turn it over to Rachel to talk through a number of the AI issues and developments, and then we'll come back and talk about some regulatory initiatives. Rachel.
Sure. Thanks, Dan. I'm delighted to be coming in here talking about AI and the future of work here. So I want to start with talking about President Biden and some of how he's spoken about AI. Let's go to the next slide. Yesterday, when he signed an executive order on AI, he said that AI is the most consequential technology of our time. And he predicted, I think accurately, that because of AI, our lives are going to change more in the next couple of years, in the very short term, than we've had change from technology previously. And one of the other things that he said that I think is really important for us to understand is that AI is all around us. And I would amend that, I would clarify that to say that AI is already all around us. So when talking about AI and where we are and where we're going, my starting point is the saying on the slide in front of you, which is the future is already here. It's just not evenly distributed. And that was actually said 20 years ago. That was from science fiction author William Gibson from 20 years ago, talking about technology. And as someone in technology, I've been asserting the truth of that for over a decade myself. I think it really applies to AI, and especially to AI when we talk about the employment context. So next slide. So when we're thinking about tools and how AI is already being used in the workplace and already being used to support HR processes, my starting point is some survey data from SHRM, the biggest human resources society. This is from February 2022. This is pre Chat GPT, pre-AI, generative AI hype. And so even before we had that hype and excitement and everyone getting excited about AI, we were already hearing from SHRM that 1 in 4 of their survey respondents, is this big survey response, 1 in 4 said they were already using AI or automation to support their HR activities. Next slide. And importantly, again, pre-Chat GPT hype, of course, the big companies said they were using AI, said they were already using AI, but there's also small companies, there's also medium-sized companies. And so, part of, I think, the promise of AI and machine learning, automate, all of these automation processes is it's not just the biggest companies doing it, it's the smaller ones also. Um, so, next slide. Um, you know, you see on this slide, and we'll be distributing these, after the presentation, that there's all kinds of uses throughout the HR process. I think if you've heard some of our other presentations, or you look up some of the things that I and others at the firm have talked about, there are really tools out there that support every part of the hiring, of the employment life cycle. Again, there's an emphasis from the SHRM 2022 survey data of things at the start of the process. The hiring and sourcing is one of the more common applications, according to that survey data. And I think with the rise of generative AI, with ChatGPT and other large language models really attaching into the public consciousness, we've seen other applications really coming out there, from generative AI and others. Okay, so future of work. Let's talk about disruption. Let's talk about what AI means for the workforce. So on my next slide, I have a quote or an assertion from Goldman Sachs as we were hitting peak ChatGPT hype. So this is from April of 2023. And so we have these Goldman Sachs researchers asserting that 300 million full-time jobs, or the equivalent of 300 million FTEs, could be exposed to automation just from generative AI. And by the way, from this slide onwards, except with 1 or 2 disclaimers, all of the pictures you'll see here are generated with Midjourney, that I use Midjourney to do generative AI. If you haven't seen some of the generative AI products on images, I think that by now everyone, or most everyone on this webinar, attending this webinar, has tried out a generative AI product in a way that is consistent with don't paste confidential information, don't paste trade secrets into there, but try it out yourself and use it in safe ways, use it in ways that make sense, to see what it can do. And one of the things that's surprised me, and I think I've had arguments with my daughter, with my teenage daughter, who's an artist, and she, my teenage daughter is absolutely livid that I'm using generative AI, for my presentations. This was like, Rachel, why didn't you commission an artist to make those slides, to make those pictures for you? It's like, well, there's lots of reasons for that. But here's some of what generative AI can do, and so we have, I think I was trying to get it to give me a sad robot, a picture of a sad robot who's out of work, and of course the sad robot is a slightly old, and a few technical generations ago, apparently, according to Midjourney. Okay, 300 million FTEs exposed to automation. What kind of future do we have in store? So let's contemplate that on the next slide. Do we have the hellish future? Hellish landscape taken over by robots and automation? Are the robots going to replace us? And so my prompt to Midjourney, by the way, that was my prompt on the left side: hellish landscape taken over by robots in automation. The picture on the right is the same prompt, but make it cute. and with some other little engineering. So is it unicorns and kittens, and everyone having the robots attend to our every need? What is the future of work here? Well, I think there is. I hate to be the lawyer and say everything depends. It all depends. Hellish landscape or cute robots. Cuddly kittens. Next slide. So what the Goldman Sachs numbers, the assertions say, and I believe they're true, and I think our experience is playing out here as people start using generative AI and other kinds of AI and automation. I believe, I really do, that most of us are not going to be replaced by AI. Now, will our lives change? Will our jobs change? Absolutely. So the graph here that we see from that Goldman Sachs report, it shows that there are some positions that are 100% exposed to automation. And there are other positions that the bankers feel are pretty safe, but the majority, the majority, within that middle section there, shows that our jobs will change and the things that we're doing will change, but will we be totally replaced? A few yes, but most no. And I think that is the future ahead of us. And so I think the more interesting question, the things that we wrestle with is, as our jobs change, as the workforce changes to embrace the benefit of this technology, what are the risks, and how does the workforce change? So let's talk about a recent case study that we have starting on the next slide, from Walmart. And so, by the way, this picture is an actual picture that accompanied the article that I cited. It's so we have Walmart talking about their use of AI on a daily basis in a retail store. And Walmart, was saying in this press tour in October that about 65% of their stores over the next 5 years are going to be serviced by automation. And importantly, they're also asserting that their workforce hasn't been reduced as the result of using AI and having their employees interact with AI. So what exactly are they doing? Next slide, people, please. So, what they're saying is their jobs are changing, that the existing retail workers' jobs are changing, with them being able to redeploy people to do different tasks. And so, by the way, what does Midjourney know about what Walmart workers look like? Well, it certainly gets the vibe of a Walmart store, and they have the blue from the logo there. So I thought that was extremely interesting to me. Okay, next slide. So one of the applications that they're doing is they're giving people an app on their smartphone. They're giving their workers an app on their smartphone that's scanning with some AR technology, scanning packages and telling the workers whether they contain items that are out of stock, so they can act appropriately. Also suggesting optimal product placements on shelves. So this is technology that is AI, that is using data, that is using a lot of the data that's coming out there, and helping the human workers prioritize their workload. And so that is a right now application that Walmart has. If that doesn't sound as compelling to you as you were thinking, let me give you an example from medicine in the same vein. So, as you might guess, there are image recognition, there are AI applications that look at X-rays, that look at films that human radiologists would apply judgment to, and you have AI that can form judgments, that can make can make decisions about those images. And one hospital system's assessment of this risk, an assessment of how do we use this tool? Do we let the AI, do we use this automated decision making to make a medical diagnosis? And the risk assessment is wait a second, that based on what we know about this model and what we know about the risks of this model being wrong, we don't want to use this AI, this machine learning model to make a diagnosis. But what we can do is we can use it to prioritize the human beings, the human radiologist's queue. That, as you can imagine, that if a radiologist is sitting there looking at all of the films she needs to assess for her shift for the evening. Some may be more critical than others. Some may be more important for her to get to sooner rather than later. That first in, first out may not be the best way to manage that queue. Or I'm gonna look at the film of the ER doc that makes the most noise, or that calls me incessantly. Maybe that's also not the best way to prioritize the queue. So there's a hospital system that's using AI absolutely to make decisions, that's using some judgment about how critical it is to get a human decision on there. But it's the human that makes the decision. And of course, there's safeguards built in that they set thresholds saying if this X-ray is sitting in the queue for too long, it needs to get prioritized eventually, even if the AI thinks that it's not very important to get to. And there's a whole host of things besides the film itself that's coming from the patient's medical record that goes into that algorithm to do that prioritization. Okay, so back to Walmart on the next slide here. Besides the retail store aspect of things, this fall Walmart also launched a generative AI product, putting a form of generative AI in the hands of all of their workers, according to what they're putting out in LinkedIn. So next slide. So according to the Walmart executives who are pushing this, they're saying, she's saying that it helps us work faster and more efficiently, and also has some challenges. And so what we want the humans to do, what the humans are good at, is the out of the box, truly brand new thinking. And the line from Walmart's chief people officer is, our humanity is what sets us apart and always will be. So the use of AI, the use of these AI tools is pushing us towards the tasks that humans are better at. Applying applying that out of the box, brand new thinking. Okay, next slide. So this isn't just Walmart, where I'd emphasize things for you is that this executive here, a Fortune 500 CIO, is talking about humans making a difference in the problem definition phase. So what problem are we trying to solve? How are we setting up things for the AI to apply what the AI is good for, what machine learning is good for? And there are, again, machine learning, AI, a lot of this is identifying patterns, right? Extrapolating from the data that we feed it. Okay, so let's go back to Midjourney. Let's talk about the upside and the downside of generative AI and some of the risks here through pictures. So what do I have here? We have, my prompt that I asked Midjourney to generate was C-suite executives using artificial intelligence. And so, when we ask Midjourney, when we ask generative AI to give me a picture of a C-suite executive, what kind of person does it give me? And let's be clear. It gave me pictures of men. If you look at the background there, they're all men. They're in suits, and they all have, they're in dark suits, and they're all, they have strong jawline and good hair, and they're white. And so when we think about what's our typical, what are our implicit biases, our explicit and implicit biases when we think who is a C-suite executive? Well, it gave me, the AI gave me a white male, with good hair. And, is that correlated to be, are those attributes correlated to being a C-suite executive? I believe there is a correlation on those attributes. And, is that where we want to go? Is that the full story? And so, that's part of, the challenge of thinking about AI. Okay, so the future of work. Next slide, please. Again, what is our future? Is it bright and fuzzy? Is with the helpful robots, or again, are we back to the hellish landscape of automation? I think the answer is going to be somewhere in the middle. That things absolutely will change, and it's incumbent on us to understand both the benefits and the risks. So, next slide, please. I want to leave you with some risk management principles before we really start, diving into some of the regulatory aspects, of things. One of the common sayings in data science, when we talk about AI, is we're talking about mathematical models. And a saying in data science from really a very long time ago, as far as math, the history of data science goes, is all models are wrong. Some models are useful. And someone whose writings and thinkings I'm very fond of, Augusto Janto, who's the chief model risk officer at Wells Fargo, he's amended that, saying all models are wrong or will be wrong. What matters is how much wrong can we accept. And I think that is part of the way that I think about risk management on AI. That there is output from an algorithmic process, and whether that's generative AI, showing me pictures and giving me something that's not quite what I expected or what I wanted, or a picture that, as we saw in that CEO picture, that may reflect some explicit or implicit bias and assumptions about roles and people. How we define wrongness and what kind of wrongness and degree of wrongness, error, unfairness, bias we can accept, is part of the question ahead of us. I think that in the context of HR tools, of the employment processes and the future of work, we have great potential here, that looking at AI and all of the data about the decisions that we're making, and that we're asking AI to help make about people, having that quantitative data in front of us has, I think, in some respects, shown us how quantitatively flawed the human-driven processes are. And so when we look at our processes and we look at disparate impact, and we look at, well, hey, how do these hiring practices affect women? How do they affect people on the basis of race, or national origin, or disability of various types? We're getting quantitative data showing us how flawed or not flawed, and to what degree that it's flawed, that the human processes are. And some of the promise of the AI is, well, it can be better than those human processes. Is better than the human processes a standard in Title VII? I don't think so. We'll talk a little bit more about that. But again, when we talk about how much wrong can you accept, and what are you going to do to see and to iterate and to stop it, and to replace the algorithmic output with your own. And when do you do that? And when, do we consider that a risk that we can accept? That's part of the challenge here. Okay, so breaking news for those of you who haven't been reading the AI coverage or the coverage in the various media in various media sources. Yesterday President Biden did sign an executive order on artificial intelligence, and some of the things in that executive order go to really global geopolitical issues, and addressing safety and security issues that some people, I think slightly breathlessly, talk that could be existential. Will AI lead to the extermination of humanity? And there are things in the EO that go to that. I want to acknowledge that, yeah, that's a thing, but there's also other things in the EO that President Biden sets in motion that I think will really move things along, that talk about, yes, there are risks associated with AI, and there is this enormous potential and this enormous desire for America to continue to lead in innovation on AI across all phases. And so one of the things that really strikes me looking at the executive order, and you can read our SciFar management alert on that went out last night, is how it's really empowering and directing all of government to look at ways that AI affects the American people's lives and to harness its power while managing those risks. And so, whether that's, talking about the National Weather Service and doing weather pattern predictions, or workforce training and disruption and redeployment issues, to the semiconductor industry and immigration and privacy and security. There's these wide-ranging practices, including the federal government's own practices on AI, that I think are extremely important. So, certainly there's things that Dan and Emily will talk about on enforcement, and I think a continuation of steps the government has been doing, but also really embracing both the potential of AI and the risks, and understanding that there's huge, enormous benefit, and there's also risks that we need to manage, and a robust conversation about how we manage those risks. And with that, I think I'll turn it over to Dan.
Thank you, Rachel. All right. Well, in addition to the hot issue of the President Biden's executive order coming out this week, we wanted to talk a little bit about some of the existing state and local laws that have been enacted, as well as some of the pending laws, which are constantly in development. We're not going to dive into depth of each of these, because it would be a full day program in and of itself just to talk about New York City. Next slide, please. As well as the others, but wanted to give you sort of an overview of where things currently stand, and obviously where there's just going to be tons of regulation coming. Presently, New York City, as many of you may know, if you have employees in New York City, or if you're using AI in any way for any employment decisions, there is a law that took effect in New York City that has several requirements for when using automated employment decision tools, principally requiring an annual bias audit to be done within 12 months of the use or implementation of any of these types of tools. There are also notice requirements, as well as requirements for certain information to be publicly available. So very, very important, if you're using any of these types of tools in New York, to make sure you are speaking with counsel and making sure that you're fully compliant. It's pretty complicated. Quickly, Illinois already has had a law on the books regarding the use of AI analysis of video interviews, and a number of requirements employers must have if using AI to analyze video interviews. Some notice requirements, consent requirements, confidentiality, things of that nature. Maryland has a prohibition on the use of facial recognition service technology unless an applicant signs a waiver. In terms of pending laws, and this is just the tip of the iceberg, obviously. California has a pending law. Massachusetts, since we are focused on New England for today's program, did want to mention there is a bill in Massachusetts that would require employers to provide notice to workers prior to adopting an automated decision system. Obviously, there's going to be a lot of layers to that. That is currently a bill. It's pending in committee. We don't know whether that current bill is going to pass or in what form, but it is in joint committee, the Joint Committee on Labor and Workforce Development currently. New Jersey has a pending bill as well, as does DC, Vermont, and others. Vermont, since we're talking about New England, did want to quickly mention the current bill there would restrict the use of automated decision systems for employment-related decisions. That bill has been referred to the Committee on General and Housing, and it remains pending. So really, we're just at the tip of the iceberg where the regulators are going and where the law is going, but wanted to give you sort of a general understanding of where things are and where to expect more to come. At the federal level, in addition to the executive order that came out today, the EEOC has issued, and we're going to talk a little bit in depth on that next, several technical assistance guidances, one on the use of AI under the ADA, and the other on assessing the adverse impact of AI under Title VII. Lastly, on the federal front, the OFCCP also issued FAQs and proposed revisions to its scheduling letter relating to the use of AI. Next slide, please. In addition, back in April of this year, you may have seen the leaders of the EEOC, the Department of Justice Civil Rights Division, the CFPB, and the FTC issued a joint statement on enforcement efforts against discrimination and bias in automated systems. And essentially, the joint statement reasserted that existing legal authorities will apply to the use of automated systems and innovative new technologies, just as they apply to other practices. So the joint statement, it didn't create new rules or new law, but it really is a reminder that the federal agencies are, A, working together, and B, the primary lesson coming out of this is the reiteration and emphasis that existing law is going to apply to the use of AI and similar technologies in employment decisions. We're going to see, and we're going to talk about right now, some of the EEOC technical assistances that have been issued, and we're going to see more in this space, certainly on the regulatory side and otherwise. But the real bottom line right now coming from the agencies is your existing legal landscape about discrimination and adverse impact and other employment rules and limitations, those apply even though we're turning to this new tool. Next slide, please. So with respect to the EEOC technical assistance, as I mentioned, existing federal and state civil rights laws still apply. They apply to the use of AI and other technology tools. And regulators usually start by applying those principles of our existing laws, many of which, as you know, have been around for decades, back to the 60s. And certainly we wish that they are somewhat updated to today's world. That's not always the case, but they still apply, and we will see how it plays out both at the agencies and in the courts as new issues arise within this scheme. But the bedrock of employment laws continues to apply. The EEOC had public listening sessions and a hearing back in January. And then, as I mentioned, they issued technical assistance first in May of 2022 under the ADA. And Emily's going to talk about that in a couple of minutes. And that was on the use of software algorithms and artificial intelligence to assess job applicants and employees under the ADA. And then about a year after that, this past May, the EOC issued technical assistance on select issues and assessing adverse impact in software algorithms and artificial intelligence used in employment selection procedures under Title VII. And so these assistance documents apply principles that are under our existing laws to the use of AI. But again, the law has not changed. It's not new law. It is discussing how existing law applies to this new use of technology. Next slide, please. So first, on the technical assistance on adverse impact under Title VII, the EOC emphasized in that technical assistance that longstanding Title VII principles apply even to these new technologies. The document was focused on disparate impact discrimination. And the EOC reiterated that it expects employers to assess any algorithmic decision-making tools for adverse impact. It's going to expect that employers are doing their own adverse impact analyses, just as you might do in a RIF, and do so in accordance with the Uniform Guidelines on Employee Selection Procedures. Some of you may be familiar with those guidelines. They have been around for a while. It's essentially guidelines from the EOC and other federal agencies that have been adopted to provide a uniform set of principles in the use of employee selection procedures consistent with applicable law and standards and validation standards generally accepted by the psychological profession and the government. Will apply these selection procedures when assessing the use of selection procedures, whether it be in hiring, RIFs, and other uses. The guidelines do apply to these procedures when they're used in any employment decisions, such as hiring, retention, promotion, transfer, etc. Next slide, please. And so in this technical assistance, the EOC reminded employers that the existing uniform selection procedures will continue to apply to the extent AI or other such tools are used in employee selections. Another thing that the EOC reminded folks is that employers can be responsible for tools that the employer uses, even if it's designed or administered by others, such as an outside software vendor. So an employer is not going to be off the hook simply saying, well, we bought this software from some AI vendor, and we're not responsible if it's having a disparate impact on women or race, et cetera. As would be predicted, the EOC is not going to let employers off the hook simply because somebody else or another entity is either designing or administering that use of AI or other similar tools. The EOC also stated that the 4/5 rule does not provide a safe harbor for measuring allowable differences in selection rates. Some of you may be somewhat familiar with the 4/5 rule that comes out of the selection procedures as well. It's a way of comparing the selection percentage of a particular protected group as compared to the selection percentage of the group with the highest selection rate. So if it's less than, if the selection rate of the protected group that you're looking at is less than 4/5 or 80% of the selection rate of the group with the highest selection rate, then it might be an indicia of a substantially different rate of selection, which then could be a red flag for potential disparate impact. And relying on that 4/5 rule, simply saying, well, look, our selection of that particular group is 4/5 or more of our highest group, that's not necessarily going to get you off the hook for a potential disparate impact claim. And lastly, the EOC stated that employers should act upon discovering that any algorithmic decision-making tool has a disparate impact result. So they're going to expect employers to actually take action if you are seeing adverse impact from the use of one of these tools. Before I turn it over to Emily to talk about the technical assistance on the ADA, I do want to share our CLE code. Please write this down. The CLE code is SS, as in Seyfarth Shaw, SS7414. SS7414. And with that, I'll turn it over to Emily, and please turn to the next slide.
Thanks, Dan. And so, as Dan mentioned, a year prior to the EEOC issuing the technical assistance document on Title VII and AI and these sorts of technologies, in May of 2022, the EEOC issued a technical assistance document as to the ADA and AI software applications and algorithms that employers are using in employment-related decision-making processes and practices. Some of the specific tools referenced in that document include resume scanning software that it ingests and analyzes applicant resumes looking for certain keywords, interviews with virtual assistants that screen responses, computer-based tests that employers may ask applicants or employees to complete, and also video interviewing software that analyzes candidate facial expressions or speech patterns. Again, some of this stuff still feels like the future to me, but it is out there. And so some of the pitfalls that the EEOC mentions in this technical assistance documents is that employers could fail to offer reasonable accommodations to employees who are using this software. So for instance, maybe an applicant needs some additional time to complete a test that the employer is asking them to complete, or maybe they need an alternative version of a test that is compatible with accessible technology that they use, like a screen reading software. So, employers really need to make sure that they're not running afoul of the law if their AI or other tools are resulting in lower scores or assessment results for individuals living with disabilities. And so we can go on to the next slide here. The EEOC makes a couple of recommendations for employers when using AI tools, like, first of all, training staff to recognize and to process requests for reasonable accommodation. As many of you know, requests for reasonable accommodation don't always look like, I need a reasonable accommodation, please, but more like, is it possible to get some additional time to complete the test? Can you make the test available on a different software platform? Those sorts of questions should start to pique your ears up to, hey, why might this person be making this request? And it really isn't likely enough to turn around and say, well, no, the test is programmed to give you 30 minutes to complete the test. That's the best we can do. So be on the lookout for those kinds of questions. Two, to make sure that applicants know that accommodations are available and how to submit those kinds of requests. Third, make sure you're not measuring abilities or qualifications beyond those that are truly necessary. What do you really need to know about or from these applicants in order to make hiring decisions or other employment-related decisions? Some of these tools have a really alluring dazzle, and you're going to find vendors out there who want to sell you on different expansion packs and other things you can do. But be careful. More tools equals more risk is the way that I'm thinking about this. So make sure you're really only measuring what you need to. And then finally, have conversations with prospective vendors about these issues. What do they know about the accessibility of their platforms, and what kinds of questions are embedded in the software that might be eliciting information about disabilities that you'd really rather not solicit at that stage of the process. And next slide, please. And just very quickly, we want to share this example not because it's factually interesting, it's really not, but because of what it signals about the EEOC's interest in prosecuting technology and hiring cases, whether or not AI, but with a particular interest in AI. And so the EEOC in this case settled its first ever technology-assisted screening discrimination lawsuit, reaching an agreement with this tutoring company that allegedly programmed its recruitment software to automatically reject older applicants. And so in this case, it really wasn't a AI type technology. It was basically a spreadsheet that automatically rejected people, allegedly, who were over a certain age. And, this, we can go to the next slide here. This case should really serve as a reminder to employers that the results of any technology-assisted screening process should comply with existing civil rights laws. And this is whether the technology is simple or whether it's complicated. If you're using technology in your hiring processes, you really should conduct regular compliance and risk management audits. As Dan mentioned, it may be required in some instances. and audit those tools to make sure that they are compliant with the new and existing laws and regulations. And I realize we are at the 45-minute mark, so I want to hand it back over to Dan.
Thank you, Emily. Thank you, everyone, for being with us for this micro webinar. If there are other topics of interest, either relating to AI or future of work, please let us know. We will be sending out the PowerPoint as a PDF, and we welcome any questions that we will try to answer in follow-up. But otherwise, thank you and have a great afternoon.